So when I met him and he told me that he was just defending himself, I worried that there's just no way we're going to be able to tell that story with the allegations as they were. But by taking it slow and walking through it step by step, he was able to show me what he saw that night and why he acted the way he did. And when he was able to do that, it dawned on me that, okay, this makes perfect sense.
They say a picture's worth 1,000 words and a video is worth 10,000. And I guess when you put it in action, it's probably worth 100,000 words.
Every single day, innocent people are pressured into accepting plea bargains and deals when they did nothing wrong.
When I was in undergrad, these cops pulled us over. I'm driving. The cop asks me for my driver's license, and I'm kind of nervous, and it's like stuck in my wallet, so I'm trying to jar it out, and he's like, "Why are you nervous? Are there weapons in here?" And I was like, "No, there's no weapons in here." So I give him my license. He runs it. There's nothing there. He gives it back. "What's your name?" I said, "Sir, I just gave you my license." His response, "I'm not a fucking elephant. Shut the fuck up, boy."
Jaden was bleeding from the wound on his arm. And rather than, hey, we need to get you to the hospital, we need to take care of you, we need to help you, he's screaming and yelling at this 17-year-old kid who's been shot for no fault of his own because he got blood on him.
Many people don't understand how that's traumatic. It causes PTSD, and people just never recover from it.
When it comes to African Americans in the United States, African American male and suspect are synonyms.
It's not right, but that's what it is.
He couldn't speak to any of those things because he had no understanding, no training in those things. So you want to get up here and testify about things you don't know, like crime scene reconstruction, versus do your job.
Your client taught the prosecutor a little bit of TOC methods.
I put out fires and I get in knife fights. And we call that the practice of law in southeastern Oklahoma. That's what I do.
Welcome to the Iron Gavel. I'm Chris, a criminal defense attorney with over 17 years of experience. And today we explore a gripping tale of justice. A story where our hero faced seemingly insurmountable odds, but emerged stronger through a strategic defense. Let's uncover the truth together. My guest today is attorney Brecken Wagner from McAlester, Oklahoma. Brecken graduated from Oklahoma City University School of Law in 2003. In the case we're going to talk about today, Brecken's client was charged with assault and battery with a deadly weapon and shooting into a dwelling. Brecken drove through snow drifts and freezing temperatures to try a case in which his client faced life in prison. The defense was self-defense, which seemed quite questionable given the fact that the victim or alleged victim was shot in the back. Brecken brought his client into the well of the courtroom and reenacted the moments leading up to the shooting. And guess what? The jury got it and delivered that powerful two-word verdict of not guilty that sent Brecken's client home after 10 years in custody.
It's 10 months.
10 months in custody. And here's a picture of Brecken and his client celebrating afterwards. They are smoking a celebratory Wagner and Lynch proprietary blend not guilty cigar after the verdict.
I have a tradition. After a two-word verdict, I like to sit down and smoke a good cigar. I don't smoke cigars regularly, but after one of those verdicts, it just feels good.
I understand that. So before we dive into the case itself, I want to let everybody know who you are. So can you tell us a little bit about yourself and your background?
I'm originally from Springfield, Missouri, southwest Missouri, where I grew up. Nothing really middle-class life. Grew up in a Catholic family and attended mostly Catholic school. Growing up, went to college up in Benedictine College, which is just off the Missouri River, up near Kansas City. And then after I played sports in high school, I did so in college. And when I Was nearing my graduation from college. I was trying to decide what I was going to do with my life. And I ended up saying, well, I'll just apply for law school and see what happens.
Where'd you play college ball?
Benedictine College. Yeah, it was NAIA school.
That was before all the money, right?
Oh, there's no money in NAIA. No.
But you know,
No.
those guys now they go there and then they transfer to the big schools and get paid.
Yeah, true. Yeah, we didn't have that. And as much as I love football, God didn't create me to be a football player.
I understand. I played in high school too, and that was it. I knew that was it. What sparked your interest in criminal defense work?
It was more beginning with an interest in what to do. Like I said, I was relatively young. I graduated young. I was only 22 when I graduated from college. So I don't think I was ready for the real world yet. And I was just exploring maybe there's something to law school. So I went to law school and I absolutely hated it. But
Yeah.
I worked my whole life. So in law school, I had to work too. And I found a job working at an attorney's office. And as much as I hated law school, I fell in love with the practice of law.
How would you describe what you do on a day-to-day basis in a few sentences?
I put out fires and I get in knife fights. And we call that the practice of law in southeastern Oklahoma. That's what I do. Constantly in cases. I carry a pretty heavy caseload, and so I find myself in court nearly daily.
We're snowed in, so I've been trapped inside all week, which is actually I hate it, but at least I'm not on the road driving to court.
That's true. In this case, a snowstorm came through here, delayed our pre-trial and everything else, and really the things you have to do right before a trial in a case happen really fast.
What do you think sets you and your firm apart in the area of criminal defense?
One thing that we're very proud of, myself and my law partner, Blake Lynch, we were very proud of the fact that we did not grow up in the profession, so to speak. I'm not a legacy. Blake's not a legacy. I always tease that the first time I met a lawyer in real life was when I went to law school.
That's true for me too.
Pretty accurate. My partner, Blake, he grew up in, I would say, poorer conditions than I did, a single mom and all of that. And he went through that. And the two of us, when we got together, we had this mission that we wanted to serve more the people we grew up with. The people we grew up with, they didn't go to lawyers. They were afraid of lawyers. Lawyers were something that was out of their circle. And there was a bit of a fear that existed. So when they actually needed help and could have used it, they didn't. And that's always been our mission in whatever area of law, whether it's criminal law, family law, we do a lot of that, property and everything else. We really try our best to serve folks who normally wouldn't go to attorneys. That's why we do a lot of free legal clinics on weekends. We just make ourselves available and try to do that as best we can. Every lawyer knows the thing, like you're walking through the store and somebody recognizes you, stops you and wants to ask you a bunch of legal
That's
questions.
right. That's right.
Yeah, and I know lots of my colleagues, they find that annoying, don't like it. I try to have a pretty humble outlook on that, I got this opportunity. I was given this. And my job is to actually stop and tell people, give them some advice, even though I'm in the store shopping just along with them. So I think that kind of thing really does set us apart for the almost 12 years we've been operating now.
Can you share a moment in your career that made you realize this is what you are meant to do?
When I discovered it was time for me to do something that me and you share in common is when I got away to a pretty special place on a ranch in Wyoming. And I went and attended some courses at the Trial Lawyers College. It was 3 weeks I was up there. It was over the course of those 3 weeks that I discovered how much I love about what I do and the people I do it for versus it being a job.
I agree 100%. I felt like after leaving the ranch, this was bigger than me, much bigger than me, and that sticks with you. I went in 2012 and I can remember the experience like yesterday. And your client, what was his name?
Jaden Richards.
What about Jaden Richards' case makes it compelling and you want to talk about it?
I think when you give the kind of the quick synopsis, the quick rundown version of what we were up against, no one is going to believe that there is a defense here. However, when you start talking about the case and what the defense actually was, I imagine anyone listening or viewing is going to step back and go, oh, yeah, well, that makes sense to me. having to find a way to tell that story, which is the most important thing we do, to tell that story so people could accept it. Because if we went along with that synopsis from the government, I mean,
That's right. Slam dunk.
slam dunk.
You ended up dunking in this case.
We end up hearing the thing we like to hear, which is not guilty.
Tell us about the initial consultation and any doubts or fears that he had and how you helped alleviate those.
I'm the one who probably had doubts first. I mean, it's just human nature. And I met him in jail. This was a referral from a colleague. He'd already had his preliminary hearing, so this was going to trial. I reviewed the preliminary hearing transcript. None of the facts were good. So when I met him and he told me that he was just defending himself, I worried that there's just no way we're going to be able to tell that story with the allegations as they were. My client was charged with shooting into a dwelling. The person did not die. The accuser did not die, but they were shot and they were injured. And the story is pretty simple. My client was picked up, was driving or riding in a vehicle with two other people, and this other person claims he gets out of the vehicle and he's being robbed by my client. He gets out of the vehicle, and as he does, my client begins to fire several times. One of the projectiles hits him in the back, the left shoulder blade, and others hit the house behind him. One goes through the window into the home and lodges in the wall above some children's beds that are not there at the time. Then the allegation is my client takes off to go get more bullets from a cousin, and as he's driving back home, no time does he ever call the cops. As he's driving back home, he inadvertently almost drives through the scene with the crime scene tape, stops when he sees the crime scene tape, goes to back up, hits a parked vehicle. Officers come over, he gets out of the vehicle, and live rounds tinkle down to the ground. He's placed under arrest, and he proceeds to lie to the officers at least 3 times.
That sounds almost undefendable.
It did.
Other than the facts, some of the most problematic evidence against your client.
The most problematic evidence was the wound to his back. The second most problematic evidence would have been the emotion prosecution could pull from the projectile that went through the house, saying it went into a child's bedroom and all that. And then finally, this was actually going to be a detriment. We didn't expect the accuser to appear. He didn't appear at the preliminary hearing. Instead, the state was able to rely on a hearsay ruling from the court to put in video of the man when he's shot talking to police and telling him that my client's the one who shot him.
I got a question about that.
Sure.
Don't all of our clients have the right, a confrontation right, the right to cross-examine witnesses against us?
You damn right they do.
How can you cross-examine a video?
What I decided to do was to not focus on that and how devastating that was, because if we don't have that video, this case doesn't go to trial and Jaden appropriately walks out of the jail. So what I decided was to cross-examine the ghost in my closing.
Oh, we got to get to that. I don't want to go there now because let me make a note. Just write ghost on my paper. Cross-examine the ghost. We got to come back to that. So tell us about the prosecution strategy in this case.
The prosecutor in this case didn't beat around the bush. He told me straight up, I got a video of the accuser saying your client did it. He's shot in the back, self-defense, and he pretty much laughed at us.
So I want to know how you developed and what was your legal strategy. If myself or some other lawyer is trying a case where the alleged victim is shot in the back, or if a member of the public, is in need of a lawyer because they believe they acted in self-defense, how did you develop the strategy, the winning strategy that you executed in this case?
In the McCurtain County Jail. We actually had to do it more or less on the eve of trial because of that's how things worked out, which I think was actually helpful. I had Jaden. We were in a meeting area there inside the jail, and first thing I did was I told him my struggle with how this could be him defending himself, and I needed to understand. And telling me about it wasn't working. So I had him get up. I had him show me. I used different techniques that we learned at Trial Lawyers College. One of being having him kind of set for me what's called setting the scene and show me what it looked like. I had him build the car, and I had him show me the car with chairs, and I sat where he sat, and I had him sit where the accuser sat, and even though there's just the two of us, we had to shuffle around quite a bit and switch places. But by taking it slow and walking through it step by step, he was able to show me what he saw that night and why he acted the way he did. And when he was able to do that, it dawned on me that, okay, this makes perfect sense. And that's when I explained to him, we're going to have to do this in the trial. So we ran it again and again so he could learn how to be comfortable building that scene, talking about it, and eventually, as you said in the introduction, come off of the witness stand and show it in front of the jury.
Do you believe this case would have been winnable had you not used the technique of setting the scene and having your client relive or reenact the moment?
No.
Yeah, that's powerful. They say a picture's worth 1,000 words, and a video
This,
is worth 10,000. And I guess when you put it in action, it's probably worth 100,000 words.
I'd say this particular instance was worth somebody's life. Yeah, it was worth that much.
Was this a case where there were experts or private investigators involved, or was this mostly fact intensive?
No, see, that's just it. The state went to the trouble of ballistics expert. They used the Tulsa Crime Lab and had a very informative lady came to the trial named Joy Buckland. I talked to her prior to the trial. She explained to me how she matched up the spent rounds. There was one found in the yard, and then the one found in the back of the accuser, and then that those matched the gun that was in the car with my client when he was stopped by the police. And the round that went into the home was inconclusive, but another thing you have to remember is there was two guns involved here. Another gun was found at the scene by a tree that can be attributed to the accuser. His name is Mr. Jalen Humphrey.
Did they do DNA tests on the weapons or fingerprints?
Didn't do any DNA or fingerprint analysis of any kind, thinking it wasn't necessary, and for the most part, it wasn't. They had two guns. Only one of them was fired. That was my client's. The other gun they showed was not fired. What was good for us, as we told the jury in opening statement, was that, yeah, we did do that. We did fire the weapon. There's no question about that, which basically rendered Miss Buckland's very informative testimony as completely unnecessary.
You never disputed your client had a gun or fired a gun. The position was it was all done in self defense.
At no point did I ever dispute that Jaden Richards not only fired the gun, he was the only one who fired a gun.
Now, I want you to tell us about some of the key moments in the trial.
Well, I would have to say, for me, one of the most interesting moments actually happened before the trial started. We have a long history, especially in this part of the state of Oklahoma, and most especially even recently in this county, in southeastern Oklahoma, Curtin County, of really deep-rooted racism against any persons of color or Native Americans, quite frankly, but especially African Americans. There is an African American population in this area of the state that's mostly derived from sharecroppers, and before that, slaves, either slaves that were owned by whites in the area or actually Choctaws. So we're doing voir dire, and my client's African American. The jury pool, the first 24 we get, includes one of the two African Americans that were on the entire panel. He was brought in and put onto the pool of 12. What happens next is the court asks questions, the prosecution asks their questions, their voir dire, and then the defense does theirs. What I found interesting is during all three of those voir dires, nobody pressed him or asked him any direct questions, and he didn't answer any questions for me. So this gentleman sat there silent the entire through all three voir dires. When we went back to pick jurors, my expectation of doing practicing law in this area for 20 years now is that prosecution is going to use their first pick, non-cause pick, to eliminate minorities. They do it in every trial I have around here. Of course, if they do that, you're going to do a Batson challenge. So I was anticipating this from the prosecutor, waiting to see what the argument would be as now this would be a race neutral to remove this juror since he has said nothing. We get through all of the picks, and they don't pick to remove him, which I was astonished by. I actually took it as a feather in my cap. Wow. People are following the law around here.
Too good to be true.
Yeah, after 20 years, stuff's changing around here. Looky here, looky here. And then the moment the record stopped, we're in judges' chambers. The prosecutor says, "Oh, Your Honor, we may have an issue with one of the jurors." And she says, "Oh, what's that?" Which he responds, "We believe one of the jurors may have a warrant for his arrest from an old misdemeanor. And we're trying to confirm that now, getting his date of birth." Would you like to guess which juror they were talking about?
The one African American male on your jury.
The one African American on the jury. The judge asked us both, "Well, what should we do about this?" I immediately said, "Turn the record on." She said, "Well, we're trying to discuss what we're going to figure out." I said, "I'm not discussing anything, and I don't want anything discussed without the record." I insisted on the record. We went back to the record, and I said all the things you can imagine I said, and how this was absolutely, absolutely about race. The judge decided to bring the juror in. He was surprised to hear he had any warrant. It was for something he was arrested for back in the summer, a misdemeanor arrest, and charges were never filed by the state. So he was released, only to have the state file that charge months later, issue a warrant that he had no idea about. This got into quite an argument, and the court decided that she would wait and see what to do after the lunch break. I'll just skip to the end and let you know. Under much protest and much of a record being made, the judge actually excused the juror, allowed him to be arrested, on that warrant, taken to jail, and used one of the alternates to take his place, who was a white male.
So it sounds like...
Yeah, she also proceeded to make a record about how this had nothing to do with race.
Of course.
Which I absolutely disagreed. And we started the trial off on a pretty rough foot.
Now, I've seen that. That seems like a common occurrence for prosecutors to try to figure out ways outside of jury selection to get rid of minorities. Seems like they were able to do that in this case, which is quite unfortunate, but that's the world we live in, and we just got to keep pushing back.
I think it's a disgusting take, if you think about it, that we had a felony jury trial and the only person that ended up going to jail was somebody who just showed up to jury duty.
Yeah, I've never seen that. I've seen people come to jury duty with warrants, but typically the judge says, "Hey, you need to go take care of this ASAP." Not, "I'm going to take you to jail for a misdemeanor." It sounds like that was all to support her record or whatever record she made. Like, look, this guy had a warrant. He was arrested, blah, blah, blah. If you were to lose and try to take it up.
Well, as I told her, she's the district judge. She could OR him right now. Under our laws in Oklahoma, having that warrant, it was a misdemeanor warrant. It's not a conviction anyway, but just having the warrant, even if it had been a conviction, even if it had pled right there, would not have excused him from jury duty, would not have prevented him from doing his job.
All right, that was definitely a key moment. So tell me about another one.
Our opening statement was Jaden's story, and that was really important. Voir dire was important when we talked about, people's prejudices and what they bring to the table, but to hear that opening statement was really important because the opening statement was Jaden Richards' version of events and how they went, which is something that the prosecution never had. They never got an interview of Jaden. They didn't investigate this matter further than they did the night of. So laying out step by step for that jury of how things went down that night and being honest with the jury was really important to let the jury know not only did Jaden lie to the officers 3 times, he was given chances after chances. At one point, the detective is telling him, "That's the other guy's story. If you got anything different, you got to tell me now." and letting the jury know he still chose not to be truthful with those officers.
So, did you do any reenactments in opening, or did you save that for later?
I actually did. I did show the jury a little bit of a preview of what they would see later by showing the motion that the accuser made, which resulted in Jaden firing his weapon. I showed them what it would look like because you got to get in your brain, how in the world can somebody possibly shoot someone in the back and it be self defense?
Tell me about your client. Let's talk about his testimony, the reenactment, all of that.
That was really important. Jaden's backstory was extremely important. One of the things that is always a focus anytime I'm defending a case is to get the jury to know my client. Okay, not just know he's some guy sitting over there, but not just know that he's been somebody who's been sitting in jail till this happened, but who is he? Where does he come from? What's his life story? What's it like? And also in opening, we covered this is part of that background. Part of Jaden's background, he's only 20 years old at the time this happens. Part of his background comes from when he's 17. Jaden grows up in a poor area of town. He is a student athlete, and then after that, he has a young daughter. A lot of things about his life are typical that we would see in poor folks living in the area. But one particular thing of interest was a story Jaden had when he was 17. We went to a party in Paris, Texas, and he carried a firearm with him. And as he did that night, as was typical among youth that he knew, he carried a firearm with him. At some point in this party, shots just start going off. He doesn't know, he isn't part of a dispute or anything else like that, but he actually gets shot in the arm at 17. He gets out of the place where the party's happening. He gets on the road just trying to find it, get out of there. As he's walking down the road in Paris, Texas, somebody drives by and actually shoots more at him. Maybe misrecognized him or something, but fires more, missing him, but driving by, shooting more. A little bit after that, he finally sees officers and flags them down, looking for help. The officers get him on the ground, they get him secured, which is totally understandable. He tells them they've got a gun on him. All that's totally understandable. They take precaution. But what Jaden really disappointed him is as they're putting him in cuffs to secure him, the officer who he's asking for help suddenly becomes angry and starts shouting at Jaden because he got blood on him.
Mud or blood?
Blood. Jaden was bleeding from the wound on his arm. And rather than, hey, we need to get you to a hospital, we need to take care of you, we need to help you, he's screaming and yelling at this 17-year-old kid who's been shot through no fault of his own because he got blood on him. That was a huge thing that happened in Jaden's life. And that also would explain later why he doesn't go to police. Why when he's asked questions, he's not going to tell the truth. He has no platform of trust when it comes to law enforcement.
Many people don't understand how that's traumatic. It causes PTSD, and people just never recover from it.
You don't. I mean, it's absolutely traumatic. Imagine, just put yourself in a relationship where there's a huge amount of trust. A parent, anyone like that, where you go to them because you're in need, and there's a trusting relationship, and that person just completely destroys it.
When I was in undergrad, I went to LSU for undergrad. It was myself and two friends. We're all in college at LSU. And these cops pulled us over. I'm driving. And they said, hey, there was a shooting in the area. And we're like, well, we don't know anything about a shooting. We don't have a gun. What are you talking about? So the cop, I'll never forget this. Dude, I was 18, 19, and I remember it like yesterday. The cop asks me for my driver's license, and I'm kind of nervous, and it's like stuck in my wallet, so I'm trying to jar it out, and he's like, why are you nervous? Are there weapons in here? And I was like, no, there's no weapons in here. You can search the car. At the time, I didn't know any better. So I give him my license. He runs it. There's nothing there. He gives it back. What's your name? I said, sir, I just gave you my license. His response, I'm not a fucking elephant. Shut the fuck up, boy. And I'm just like, okay, we're at a gas station, My other buddies, we're all in college. Like, nobody's involved in anything nefarious. And these guys hem us up for 45 minutes, call for backup, search the car. There's nothing in there. No weapons, no drugs, because we weren't into those things. But look, I'll never forget it. And I'm always telling my kids, just comply. Even if they violate your rights, just comply. You can't do anything about it on the side of the road.
I agree with you. And as I told Jaden, and I tell anyone that I come into contact with, any of my clients or just persons, especially persons of color, I tell people all the time to be very aware of law enforcement. But also, when it comes to African Americans, African American males for that matter, in the United States, African American male and suspect are synonyms.
That's not right, but that's what it is. Yep, I agree with you. So tell me, so you do the reenactment with your client. I'm assuming it goes well, and then go ahead.
A very key moment before that was the second day of trial, and it was the cross examination of Officer Zapala. It happened right after lunch. Before this was the direct examination of Officer Zapala. Officer Zapala is the lieutenant. He is the man on the scene. It's his investigation. He's the dude in charge. Anyone else has testified up to this point, they're all talking to him. They're all reporting to him. So the direct examination happened right before lunch. I took my notes and I felt very good because if it's one thing I've learned to do over the years is to cross-examine police officers. The best way I've learned to cross-examine them is to use their job against them. You know, you have certain expectations and standards that we put on law enforcement, and when you apply those, a lot of times to the specific case and to the officer, it's rare that they meet those expectations. That was going to certainly be the case here. So, a very key moment in this trial is I turned to Jaden, and we'd been talking about he's got to be ready to get up there and testify, be ready. And I told him, you're going to go back to the jail and get your lunch. I'm going to go work on my cross, but I expect that the state rest today, and you're going to take the stand. You're probably going to be the last thing that happens today. And I said to him, this is exactly what I said. I said, when we come back, we're going to do this cross-examination. I'm going to melt this cop's face from his body. You're going to see it. I'm going to take this man on and challenge him, and it's going to be brutal. You have to do your part. I'm going to set this up, and you have to bring it home. He told me he was going to do his best. We both left with on our own little missions. When we came back from lunch, I did exactly that. I walked Officer Zapala through his lack of investigation, extreme lack of investigation. We talked about when an investigation ends, which an investigation doesn't end until there's a disposition in the case. So I got to point out that even yesterday, when we were asking questions, you still could have done something about this. And you don't. You just sat here. And at the end, he's got to answer yes to all of these things. And we're not mean about it. We call it a story cross. And just take them through what they did do and what they didn't do. And one of the best moments came actually on recross after a redirect. The prosecutor, obviously frustrated with how his officer had performed, I think was seeing that they had a problem. They had a problem because they didn't have a story. They just had some facts to throw out there, but not a story behind it. So the prosecutor gets up. He essentially asks the lieutenant if he has a theory. I could have objected. I was about to object. He's essentially asking this officer to just speculate as to what he thinks happened. And I don't think it would have survived the objection, but I sat in my seat and I waited because I want to hear this too. At this point, Lieutenant Zapala begins to talk about how he thinks it went down is that the accuser was being robbed and gets out of the car to run. As he does so, he drops his own weapon, and Jaden begins walking down the street behind him, firing. several times, one time hitting in the back, up and down the street. And he says he believes this because the spent casings are zigzagged up and down the street on both sides of the street, it appeared to him, and on and on and on. The other thing he's asked about is, and your listeners need to know, is there was an eyewitness. There was a gentleman who was driving the vehicle. They knew about this gentleman driving the vehicle the night of the incident. They heard from a neighbor who had a Ring video camera of the vehicle speeding off. They never even take the tape. They don't look at the tape. They don't look to identify the driver. They don't look to identify who's even in the vehicle, if anyone. They don't even look to identify the vehicle. One of the questions comes up during the trial is whether or not there's a car being driven by my client or a SUV being driven by another person. The officer's excuse as to why they don't seek out this driver is because he's difficult. He doesn't have much respect for law enforcement. They're familiar with him. And interviewing him, they didn't think would do any good. That's what we had on Redirect. So that set up a beautiful moment for me to confront this officer and ask him some questions. And that being about his background and his expertise. And what I essentially asked him is if he, his training, does he have any particular training in interviewing? And of course he does. Does he have any particular training in interviewing difficult witnesses? Well, of course he does, including witnesses that might have poor thoughts when it comes to law enforcement. All those questions are yes. He's trained in specific techniques. We even talked about different techniques and the names of those techniques. Then I asked him about his training when it came to crime scene development investigation, because he used the word trajectory on direct examination. So we established when it comes to crime scene investigation, he has no training other than what training he got at the academy. He doesn't know how to use trajectory rods to determine trajectory. He didn't even take pictures of how they're scattered up and down the street, even though he claims this is part of his theory. He couldn't account for where the shots came from, whether or not the vehicle took off while my client, still afraid, was firing, and that might be reasons why casings were in different places. He couldn't speak to any of those things because he had no understanding, no training in those things. That's for people who have that training, which leaves you the final question, sir. So you want to get up here and testify about things you don't know, like crime scene reconstruction, versus do your job and use techniques you do know, like going and getting people that are difficult to interview and doing that. You didn't even attempt that, but you're going to get up here and just lay your theories down. That made that officer look pretty small, and it made the case look even smaller. And that's where we sat down, and the next thing that happened was Jaden took the stand.
Did we talk about the reenactment with Jaden or?
No, we haven't. So we decided the best way to reenact this was just the part where he fired. Jaden's story is this. He gets picked up at his home by his friend Champ. He's expecting Champ because Champ calls him. So when Champ arrives, he walks out to get into the SUV that Champ is driving. He goes to open up the passenger door, and when he opens it up, he sees a gentleman that he doesn't know his name, but he recognizes. That's Jalen Humphreys. That will later be the accuser. He gets into the passenger seat right behind Mr. Humphreys. Then they start to drive around, and the purpose of this was just to hang out. And Mr. Champ had told him that he had a bottle of 1800. So then these two gentlemen start taking slugs off this bottle and passing it around. They keep handing it to my client, wanting him to, oh no, take another shot, take another shot. Meanwhile, the passenger is holding a pistol in his hand. He keeps looking at it, keeps talking about it, just showing it up, but holding it above his shoulders where definitely Mr. Richards can see it from the back seat. At one point, Jaden gets kind of nervous because he finds they've driven into this neighborhood that he knows they don't belong in. The reason they don't belong in is this is a neighborhood with manicured lawns, multiple story houses. This isn't a place for young black men to even be driving around in because they're going to be stopped. So Jaden gets nervous. The pistol that Jaden has in his waistband, he takes out and he just holds it on his lap. At one point, Champ pulls the car over to the curb. Just not any particular place, just in front of this two-story home. Just pulls over to the curb. Stops the vehicle, and the driver looks back to Jaden and then looks over to the passenger. At that point, the passenger turns all the way around, puts his arms over the seat in a way, and leans over it, holding the pistol, points down to the pistol in Jaden's lap and says, "Let me take a look at that." Jaden, sensing something is very wrong, pulls the slide back and puts one in the tube and just says, "Nah." At this point, the accuser, Mr. Humphrey, says something to the effect of, "I'm not dealing with this bullshit," something of that effect. Opens the passenger door, and this is where I stop, Jaden. And I say, "Are we about to see what happens next?" "Yes." "Would it be easier for us to explain this to the jury by being able to come down off of the stand into the well and show them what happened next?" To which he said it would. I asked Her Honor if he could do that, and if you ever do that in trial, I've never had a judge tell me no. She didn't tell me no. So he came down. I had put some chairs to the side in preparation for this, and he built the car, and then he showed us what happened next. I sat in the seat where he sat, and he showed us how Mr. Humphrey opened the vehicle, exited the vehicle, took 2 steps directly from the vehicle, and he had his hands in front of him, and then in a very quick movement, turned back over his right shoulder and held his right arm out and looked over that arm, his feet staying pointed forward. And in his hand was a gun. And when I asked Jaden what he saw, he said, "I saw the barrel, I saw the tube of that gun. And the moment I saw that, I fired."
Not even seeing that reenactment, but hearing you describe it, I feel like a shift in myself from how the hell did he get a not guilty to I get it. And I wasn't there in the courtroom to see what the jury saw.
When on his cross examination, which we prepared Jaden for, I have a technique I used to do that, deal with prosecution or deal with any cross examination. And he weathered. All you got to do is weather the storm. That's what we talked about. Weathering the storm, weathering the yelling, weathering the accusations, and letting me be the one to engage the attorney when he goes too far. We did all those things. Jaden followed his instructions to a T. He did exactly as he was supposed to do. At no time did we ever talk about what Jaden was going to say, or tell Jaden that it needed to be this or that. Just how to answer the questions, how to listen to the questions. He did a great job. And on cross-examination, the prosecutor asked him to come down and demonstrate it again, not once, but twice more. And both times tried to argue with Jaden that he showed it a different way the times before, which my man very politely said, "No, sir, that's not how it happened. I can show you again." It's
Oh,
beautiful.
wow. Perfect.
Yeah.
You're looking at the prosecutor like, thank you for.
I'm not objecting to that. And also, they used the car. This was a moment where I realized that my client was invested, obviously invested, but invested in the telling of his story as I was. Because when we set a scene, we see it as real, right? So as we were practicing there in the jail and he would enter the car, I said, "That's a car. How do you enter a car?" "Oh, you open the door." I said, "You open the door. Okay, and you don't walk through a car. You sit in the car. Don't sit on one side and then walk out the other side. People don't do that, do they?" "No." "And don't let people walk through our car." "No." At one point, the prosecutor walked through the car, and Jaden went ahead and corrected him that he's walking through the vehicle. That's not how that works, and that's a beautiful moment.
Your client taught the prosecutor a little bit of TOC methods. So, tell me about the prosecutor being adamant about using the gun in his presentation and how the exchange y'all had.
There was an exchange that happened at the very beginning of the trial. It was kind of cute, but also important too. prosecutor, there's always that banter and that kind of chest pounding that might happen between attorneys for a trial. It's just try to, I guess, intimidate or what have you. And this prosecutor has been doing this longer than I have, and I've been at it a while. And if you get around somebody that's been doing it for quite a long time, they love to tell you that. And he was doing that. He was telling me, well, in all of my trials, however many I've done, he wanted to tell me that so many times. I've found that instead of having a picture of the firearm, it's better to have the firearm itself. You got to have the firearm. The jury wants to see the firearm. So I am having the firearm brought in, just to give you a heads up. Not that he's worried about what I think. He's just going to tell me what he's doing. But I am having it brought in just to let you know, in case you have a problem with it. I said, no, of course I don't. I said, I think it's an excellent idea. We need to have the firearm here. As a matter of fact, it'd be good for us to have it here because we're going to need it back in a few days. To which he stone-faced looked at me for a moment, then kind of chuckled and laughed. But he wasn't laughing at the end when after he brought me the verdict form, I said, hey, Jeff, since I'm here today, let's go ahead and get that gun back.
Look, your client has a right to possess his firearm, and the case is over.
That was one of the things in their closing I found interesting was the prosecutor in the rebuttal closing. The rebuttal closing was essentially everything Mr. Wagner said in his closing. Well, his theory just doesn't add up. They didn't even talk about their theory of the case, just about the defense, which has no burden. And they didn't have an answer for the problem they had, which was because they didn't have Jalen Humphrey there to testify, because he's got a lot of baggage. But the ghost of Jalen Humphrey did show up, and it showed up in that closing argument.
Tell us about the ghost of Jaden Humphrey.
That was the interesting part. It came out during the trial, some things about Mr. Humphrey. Mr. Humphrey had a criminal background. Nothing serious, but he had some charges of violence out of Texas. He also had a gun charge out of Oklahoma. You're talking to my client, they had to agree that he had no criminal background. Some other things about Mr. Humphrey is there was inconsistencies in statements that even though the hearsay statement came in, I was able to impeach with his written statement. So there was inconsistencies there. There was things that he was telling that didn't add up, that didn't fit right. And my favorite part of all was Officer Zapala had to answer yes to the question, you had doubts about his version of events because he wrote that in his report. So you have everyone that we're not so sure about is this Jalen Humphrey guy. The jury had the benefit of watching me cross-examine officers and other people for 2 days now. So when I got to that point in my closing, I asked them, we don't have Mr. Humphrey here to give his story. We have Mr. Richards here, my client, to give his story. He sat there when he didn't have to, something we covered in Voidar. When he didn't have to say a word, he sat there and allowed that trained attorney to stand up there and shout at him and yell at him. One of the things the prosecutor did was he asked the same question over and over to the point where him and the judge got into it over my objections for asked and answered, because they clearly were. So I point out he just kept asking the same question, wanting a different result, and Jaden had to sit there and deal with that. So I get to turn to the jury and said, let's imagine if Jalen Humphrey, the accuser, actually did show up and he sat in that witness stand. You've got to watch me for 2 days. You think I'm just going to yell at him and ask the same question over? Jurors would shake their heads. You think I might ask him about his participation that night and what he was up to, why he joined along at the last moment, why he had a gun, why he was showing his gun, why he wanted to have both guns and one person have no guns. Why was that important to him? Or why did his story change so many times? It went on and on and on. I said, you get to ask yourself, how would I have asked that question? And the jury got to sit there with that, and they had to live through a cross-examination that never happened and weigh that against Jaden Richards' testimony that he had a constitutional right not to even give. And that became a powerful thing for the jury when they went back into deliberations.
And just so the public is aware, this guy, Jalen Humphrey,
Yeah.
he did not have a constitutional right not to testify, right?
That was important that came out in closing too, is going back to what we talked about in Voir and how our justice system is supposed to work. And the history behind that. I love to talk about the amendments and I love to talk about the Fifth Amendment because, it's as old as our founding. This idea was so important to the people who created all of this. It's number five. Think about that. It's the fifth most important thing, at least if we rank them according to how they're written by the founders. It's the fifth most important thing that every citizen of the United States has. And we ask in Voidar, when do you get those rights? When you're born. When do you lose them? Well, when either the government has a legitimate reason to take them from you or you die. And when you put that much power and emphasis behind that, it helps a juror, a citizen, relate to, wow, this is that much bigger than me. It's so important we made it number five.
I'm going to steal a lot of what you talked about. I can't wait to cross examine a ghost in my closing.
Those are the best.
This is you and your client after the verdict.
Yes, sir.
Tell us what was going through your head while waiting on the verdict, because I know that can be quite stressful.
I was sitting alone. It took about an hour. I have a traditional way of dealing with that. I'm not good. I need a moment. So the moment the jury usually gets the case, I try to explain to my client and their family beforehand, I'm going to have to go take a walk. I go take a walk, usually around the block or somewhere, just to get away. And then we just wait. I will tell you that in the last 15 minutes waiting for that verdict to come back, I went through everything a human being goes through. And your confidence begins to whittle away and you start to accept doubt, even though you don't want to. So you go through all that. No matter how good it feels during a trial, it twists your soul. It's the worst part of any trial, is the waiting.
How about your client? How was he during the deliberations?
Because Jaden was in custody, something that I tell my juries, because he was in custody, he was taken to his holding cell. He sat in a room alone, just as he had sat in a room alone for the last 10 months. For Jaden Richards, this 20-year-old young man, to do the things that needed to be done by him in this trial to give himself the best chance, after what he had endured, he didn't have a cellmate. For 10 months, he sat in a cell by himself, in a jail, the conditions of which are appalling. That's every jail in southeastern Oklahoma. This one's no different. And to be able to get up there and do that, I'm not that person.
I'm sorry, tell us about the jail. You say the conditions are appalling.
It's an old jail. To those old jails that are connected to the courthouse. The old style jails that are right next to the courthouse. There's peeling paint, the smell. You can see mold. And to be in there also with the added torture, that's what it is, of isolation. It's just appalling.
When you guys heard the verdict, how was that? Any tears?
I don't recall any immediate tears. His grandma and his mama who attended the trial every day, we were all emotional. But the most emotional moment, there had to be a whole process, some things we had to go through for Jay to be released, before he could be released. As we're standing outside waiting for that process to conclude, I'm out there with his mom, and when the school bus happens to drive by at that particular time, and his mom hops in the car and goes and gets her little boy, Jaden's little brother, I think he's about 4 or 5, and Jaden's daughter, Noah, who had been living with her grandmother and without her daddy. Jaden has custody of her, been living without her daddy for 10 months, and brought him up there. And they were so excited. And to watch that little girl pick a dandelion for her daddy, knowing that she was going to get to see him in a moment, was really an emotional moment. I had the privilege and honor of being right there when Jaden walked out of the jail, and those two little kiddos ran up to him and gave him those hugs and kisses. That was quite a moment.
Based on what happened in this trial, is there any type of legal reform you would like to see, or changes in public perception, or things we can simply do different to ensure that people are given a fair trial?
There's those things that we do have control of, those things that we don't. The thing that I think is important to get out, especially the public, is the public's perception of what goes on in a courthouse and what actually goes on in a courthouse There's like an ocean between them.
That's
It's not until you've been a juror, you've performed that duty, I think that you really get a sense of one, how important that is, how important the jury system itself is, and how in all the problems we have in the criminal justice system, it's the only part of our system that I would say is pure, is fair. So to really continue to have respect for that and to honor that. At the same time, we need to start understanding that every single day, innocent people are pressured into accepting plea bargains and deals when they did nothing wrong. And the reason that is because the punishment typically to any crime is so disproportionate to a crime. I mean, the idea that a misdemeanor can carry up to an entire year of incarceration is ridiculous. This young man had no criminal record. Just by the charge that was filed against him, was facing the possibility of spending 45 years, and because it's a violent crime in Oklahoma, 45 years is life. That's how life is calculated at 85%. As the jury was instructed, if they found him guilty and gave him life, which is what it carried up to, he'd be in prison for 38 years before he would be eligible to be paroled.
You're allowed to tell the jury that in Oklahoma?
One of the things I think that Oklahoma can teach the rest of the states in the union is that here juries have a role in sentencing. Juries recommend sentence. If we're going to have that disproportionate, comes to being tough on crime BS we hear from our politicians. We're going to have that disproportionate, oh, he's accused of X and may have done it, let's bury him under the jail type of thing. Then at the least, we should have the jury, the community from which that man comes. As I explained in closing, we are the community. The folks sitting at this table, that's government. We're all one. We are the people. That is government. And government doesn't get to take one of ours away until we give them permission. That's what a verdict is. The jury is democracy. They're the ones implementing the law. They're the ones deciding ultimately what we will do with it. And they are not going to be questioned on their decision. It's what they feel. So if we're going to have that type of system where we honor a jury should have the ability to pass a sentence on their member instead of that being left up to government. That's one thing I think we could absolutely change in this country.
I wish we would adopt it. Here in Louisiana, we don't get to even tell the jury what the penalty is unless it's a life without parole case. And in Louisiana, life without parole is you go to jail and you don't get out. You're there until you pass away.
We have life without parole, and we're very big on killing people in Oklahoma, so I understand.
There's a lot of reform that can go on in probably your state, my state, and many other states in the South.
I will tell you, from somebody who practices criminal law, I have tried cases with a guilty client. There is something beautiful about that when it happens. You can stand in front of a jury, this man's guilty, essentially have a trial over what we call mitigation. That should be something we do across the country.
If my client's clearly guilty, he's clearly screwed.
Rather than leave it in the hands of an elected politician, aka judge.
And they become jaded. The longer a judge sits on the bench, the more they become jaded and just assume everybody's guilty. And I've seen judges who were brand new judges 17 years ago when I started, and they were great for maybe the first 10 years, and then they became so jaded.
Well, we all do. We all are, Chris. I mean, any line of work you go into, if you talk to healthcare workers, they will have a certain skepticism that comes over them after doing it for so many years. Law enforcement, everything we do, as attorneys, we go over there, we joke around or cut it up with prosecutors, and we never take into consideration what that might look like to somebody who sees that, and they only see that prosecutor as someone trying to take their life away from them. And here's the person they've put their trust into cutting up with them. We don't see it that way. We don't get that view. But if you start walking in others' shoes, it starts to make sense to you. We're jaded too. We cut up and make terrible, terrible jokes, gallows humor. That all comes from that. And it's our way of helping us to survive because this is difficult work. But that's why it should never be in our hands. It shouldn't be. It should be in the hands of the people who the law is for.
I certainly appreciate this. You were my first guest ever. I interviewed one of my clients a few weeks ago. I'm going to release that. This is something I kind of wanted to do for a while. I enjoyed it.
You're onto something good here. I like what you're doing and telling people not only what goes on, but how we can make it better.
If someone wanted to find you or reach out to you, what would be the best way for them to do that?
We practice mainly in Oklahoma, however, all over the state of Oklahoma. But we also work with other folks in different states, depending on the type of case. My law firm is Wagner and Lynch. We're pretty much a general firm. We handle all kinds of different disputes and things come in the door. My particular area of practice I focus on is criminal defense. And we're out of McAlester, Oklahoma. You can follow us on Facebook. We do a lot of social media work on Facebook, and we try to put out some information there. You can contact us by email. All of our contact information is on our Facebook page. I'd encourage people to go to Wagner and Lynch on Facebook, and you can get to our website from there and all other places and kind of see what we've done. I love to educate from our experiences, so I have a tendency to write about trials and cases we do. And there's an archive on our website where you can see some of those stories that from my career that some are pretty incredible. There's a story out of a trial in Poto, Oklahoma, where I had to explain to the jury that I can't stand my client. He hates me.
Oh, wow. I may have to bring you back on to talk about some of these other trials.
There's situations like that. We've had some pretty interesting trials over the years. We had a rape trial here that the accuser was in a full halo brace thing. It was interesting. I had a child abuse case in which there was a full confession that resulted in a acquittal. And it was a perfect example of how a confession can be a false confession and how officers can use techniques not to find the truth, but to find what they think, for a conviction. So there's lots of stories on there about myself and Blake's exploits over the years. It's a good place to go to find some of those.
I may go look myself in it and then see if I can pull you in to talk about another one.
The big one that we're most proud of was years ago in Norman, Oklahoma. Myself and Blake did 3 jury trials regarding the sale of glass pipes. It was a big deal before Oklahoma had medical marijuana, and I like to take credit because it all came around the same time. In the months following the last of those trials, Oklahoma became a medical marijuana state, and I like to say that me and Lynch, we're going to give ourselves at least 15% of the credit for that. Yeah, good stuff. But it was wonderful. I enjoyed it very much, and I wish you luck in the future with it.
All right, thank you. Same to you too. If this story resonated with you, or if you know someone who is facing legal challenges, subscribe and share this video with them. Join us in spreading knowledge and support for those in need of justice. This is the Iron Gavel, folks, signing off.